Okay, well, let's kick it off. I want to say hello to everybody and welcome you to our webinar today. This is one of Wild Apricot's monthly expert webinars, and today we're honored to have Erin McClarty on with us. Erin is a non-profit attorney and strategist. She's going to share with us 5 common legal traps that she sees nonprofits face and how you can avoid them. This actually isn't an issue we've really touched on too much here at Wild Apricot, but it is an important one because, of course, the last thing you really want are legal issues standing between you and getting on with fulfilling the purpose of your organization. So, I'm really glad that Erin could join us today, and I hope you're all looking forward to it. And we'll bring Erin on shortly. In the meantime, I want to introduce myself. So that's me, Donald Cowper, on the left of your screen, and I'm on the Wild Apricot content team. And beside me is my colleague, Rano, who will be joining us here to help with chat and any technical issues you might have. I am happy to say that the snake that you see around his shoulder in that picture is not with us. That actually might cause some legal issues here with me, but we're in a snake-free environment. So during the webinar, do feel free to ask any questions to us or to Erin. And to do that, you can use the chat box. I want to make a couple of quick reminders before moving on. First, I want to let you know that we are recording the session, and we'll be sending you an email with a link to the recording within the next couple of days, so watch out for that. I also want to let you know that by attending today, you are eligible to earn 1 CAE credit if you collect those credits. And then we'll get going in just another couple of minutes, but just let me briefly say that today's webinar is being brought to you by Wild Apricot. I know that many of our customers are here with us today, so hello and thank you for joining us. I also know that we have many people here who aren't familiar with Wild Apricot and are new to the Wild Apricot world, and I want to welcome you as well. And for those of you who don't know, Wild Apricot is membership management software. It's actually an all-in-one solution for anyone running a membership organization. And that's because you can manage your member and contact database, you can run your events, you can build your website, process all your payments, and so on. And many of our customers consider it a lifesaver because it saves them hours a day in administrative tasks, which frees them up to focus on fulfilling their organization's mission. And we're quite thrilled with what many of our clients have been able to accomplish. We've watched many of them grow since we started 10 years ago, and they've watched us grow too. And thanks to our customers, as you can see, we've been ranked as the #1 rated membership management software solution on the market for the last 5 years running. And while we do pride ourselves on helping people with great software, we're also a leading provider of free educational content, which you can find on our blog and in webinars like we have today. If any of you do have questions about Wild Apricot in particular, we are happy to answer them at the end of the webinar. So if you're free, you can stick around with Rano and myself, and we can talk about any questions you might have. So now, let me introduce today's presenter. Okay, there you see Erin on the screen there. Erin McClarty started her career as counsel for international Fortune-rated companies, and now she lives out her passion providing strategy, business consulting, and legal services to mission-focused organizations. Her clients range from startup businesses, not-for-profits, social enterprises, and foundations, as well as community centers, public-private partnerships, government institutions, as well as individual leaders. Essentially, as Erin says, anyone or thing that wants to create, grow, or manage their positive impact. Erin also writes a blog on legal issues for mission-related organizations, and she is currently working on a how-to book for charities. We'll share some links to resources like Erin's blog later on, so stay tuned for those. In the meantime, let's bring on Erin. So, Erin, I just want to say it's wonderful to have you with us today. I want to personally thank you so much for all you've done in preparation for this afternoon and for being here right now. So I'm going to pass the presentation to you just momentarily. Just let me mute myself, and then you're on. Thanks, Erin.
Here we go. All right. Well, thank you so much, Donald. I am incredibly excited, believe it or not, to talk about this topic. Just a few things, as Donald mentioned. There will be a Facebook post, I believe, after the presentation. Usually there's a ton of questions and they get incredibly complicated very soon. And so where you have one that we don't have time to answer, I do encourage you to post to the Facebook group, and I will be trolling that to make sure that I'm able to answer any questions there. And also I do encourage you to be thinking of questions as we go through the presentation and put them in the chat box. So we will get started. As mentioned, I'm going to talk about some of the most common legal traps I find nonprofits get into and ways to avoid them. But first, my short story. As Donald mentioned, I started my legal career as legal counsel for Fortune 500 companies, both here and in France. And I spent a great deal of time watching theoretical best practices slip by the wayside in the fray of day-to-day operations. And my role was to identify the risk and adapt practices in a way that allowed the clients, to follow a workflow and to keep things from going completely left when there were slip-ups. And so today, I get to use a lot of that experience working with impact organizations. As mentioned, I work with charities, hybrids, small businesses, foundations, social enterprises, you name it, either helping them structure their missions and their visions around impact measures and business modeling, or actually helping create the organizations themselves and managing them. And not surprisingly, I encountered this phenomenon of best practices slipping with the same vigor that I've encountered it with the other organizations I've worked with. And I think that's just an occupational hazard of trying to save the world. And so in terms of our goal today, I like to manage expectations. We have less than 45 minutes, really. So this won't be a mini law school class. And frankly, I don't want to put anyone to sleep. So it will be a really, really, really high-level overview of risk concepts and different ways to navigate them, or at least corral some of that risk. So the goal today, create awareness for you guys and really get you thinking about different cost-effective solutions. And, at the end of the day, why does it really matter anyway? So we've all heard these catastrophic stories about the executive director of a food pantry that gets walked out by the cops after purchasing a Lamborghini with program funds. It happens. But it's a rarity, and I don't want to use that as a carrot today. I really want to focus on the reality. And the reality is, not thinking about the quote-unquote legal stuff makes it unnecessarily hard on you guys. I've had many clients and watched even more organizations have to spend really hard-earned funds, not on programming, not on salaries, not on benefits, but on legal counsel and investigation fees and on court fees and on penalties because they weren't thinking about that legal stuff. Others have lost critical funding after losing their exemption status or failing to file something. Not to mention there's the reputational damage, loss of trust, etc. So I say it matters because really organizations can't afford to treat it as if it doesn't. And so we'll get right into the common legal traps. And the first one is forgetting to keep books and records and making them public. Some of you may be scoffing. It seems pretty straightforward, but this is another one of those things that in the day-to-day just tends to go by the wayside. What I find happens is people wait until about an hour before the board meeting. They troll receipts and account statements. They throw everything into some vague line item like special projects. And I've even had some clients tell me that they didn't keep books and records at all for some specific period of time just because they got busy. And here's the problem with that. Many states provinces, I know we've got some folks in Canada, so shout out to you, and in other places, there's a requirement for bookkeeping. And they legally require organizations keep books and records as a form of accountability. Why? Because you're dealing with public funds. So not adhering to this requirement, not keeping books and records, can not only be a legal violation, but it also could be a criminal offense. Here in Texas, it actually can be a criminal offense not to keep books and records. And so in addition to keeping them and making sure that we keep you out of prison, something else to be thinking about is the publicity requirements. Some states, provinces, and countries have requirements around the access that you provide to these books and records. So you have to be thinking about, when do we have to make them accessible? Where do we have to make them accessible? How do we have to make them accessible? To whom do we have to make them accessible? Again, here in Texas, just because I'm here, you have to keep a copy of your books and records available for inspection at the principal business place registered with the state. So there's a very not stringent, but there's a pretty coherent requirement in terms of how that has to be kept, and it ranges from state to state, it ranges from place to place. But these are things that you have to be thinking about. As an aside, I have actually had attorney generals here tell me that where they're looking into organizations, they will drop by the site and they will ask for these books and records. So it is something to be thinking about. In terms of solutions, for most organizations, I find their nervousness in doing something like going public with their books and records deals with a loss of control. So what I tell them is create a process ahead of time. Be thinking about, again, what has to be disclosed, when, where, how, to whom. How are we going to handle abuse? Because again, not everyone's going to be asking for books and records with good intent. Work this all out in a memo ahead of time and get everyone on the same page. Also, treasurer and accountant are pivotal. A lot of people say, oh, you know, when you get started, you need to have an attorney on your board and you need to be hiring a lawyer. No, I say an accountant is worth their weight in gold. They don't have to be full-time. They should have experience, be able to do things like add. I know that sounds fundamental, but again, you would be surprised. And so be thinking about and be recruiting as some of the first people you involve in your organization, an accountant and a treasurer. Never, ever, ever, ever italicized and in bold, give control of your books and records over to one person. And the minute someone asks you to do this, it is a red flag. I know that you're probably sick of the term internal controls, but it's so, so important. And really, I would say, honestly, it's a legal obligation. And so, again, the person writing the checks shouldn't be getting the statements. The person depositing shouldn't check the deposit receipts against the books. You know, if your staff is small, which I completely understand, think of outsourcing some of these responsibilities. If money is a concern, be thinking about pooling with others possibly to outsource and have everyone pay their share. And then publicizing, make it easy. There may be specific requirements, so you need to look into what's required under your specific law, but it can be as easy as posting a link on your website, using GuideStar, Charity Navigator, etc. So next to the next legal trap, unintentionally putting board members and officers in danger. I bring this up because this is where organizations start to slip into what we will call questionable practices without really understanding the implications of them. And so here are a few examples. Unimproved compensation, paying out compensation kind of willy-nilly, making unlawful loans or loans that are a bit questionable in terms of ethics, having an inactive board, forgetting reports, and really the biggest that I tend to see, I have private benefit here, but private inurement is also an issue. And I'll talk a little bit more about that because this is one of those things that can seem kind of small potatoes, but if it becomes normalized, and it usually does become normalized, it can easily snowball into something that's really catastrophic. And so a great example of this is I have member organizations that are clients of mine. And sometimes they'll pay certain benefits to board members or certain classes, things like financial benefits, health benefits, they'll pay for retreats. Well, with the wrong fact circumstance, this actually in many instances can be a private inurement, private benefit issue, i.e. a violation, i.e. a problem. And so where you can see this snowball is if it is found that there's a violation, you may have penalties and taxes in the US that you would have to pay to the IRS. All right. If there's an excess benefit, some type of transaction, in addition to that, there may be some personal responsibility, which means your board members would out of pocket have to pay certain penalties on the amount. Now, what happens is the IRS actually has a reciprocity arrangement with many of the state agencies. So they'll knock and say, hey, state agency, we found this. You guys may want to look into this as well. And so what happens is the state agency starts to look into it. Now you may have taxes and penalties that you'll have to pay to them. If the fact circumstance is bad enough, and by fact circumstance, I mean if the facts are bad enough, there could be a situation where it's found that you've breached, board, your fiduciary duties. What's the problem with that? Well, if you've breached your fiduciary duties, then you may lose indemnity protection. I know this is a lot, so stay with me, but your indemnity is basically protection. If there's a claim that comes up, if there are investigation fees, attorney's fees, court costs, indemnity is what the organization offers you to cover any costs that arise from the claims or the investigation. And so if you've breached your fiduciary duties to the organization, you may not be entitled to that indemnity. You also may not be entitled to the directors and officers insurance that you've purchased. And of course, it would be really catastrophic if the fact circumstance is bad enough that you could possibly lose your tax status. So just, again, there's these practices that we get into, guys, that get normalized. We don't know where it started, who approved of it, and usually we don't mean anything by it, but if we're not aware of the implications it can have, it can easily snowball into a bigger issue. Another one that tends to be a big issue is the inactive board. Certainly you don't want a micromanaging board. Those are no fun, as indicated by the thumbs down, and they're not sustainable because everyone burns out. But by the same token, an active board, a differential board that is consistently deferring to its executive director, is a breach of their fiduciary duty. And board members have to remember that regardless of who makes what decision, they are ultimately responsible for the actions the organization takes or doesn't take. And so, if you start out with a board that really loves its executive director, trusts its executive director, and is just incredibly deferential, completely disconnected, what seems like small potatoes, again, can spiral into a bigger issue. The trend that I have found is where I have seen issues crop up that have resulted in some type of legal implication. Usually it is because they've had a board that was not active. So in terms of solutions for this, what I would say is if anyone asks the question, can we do this? That is a red flag. It is an indication we need to pause, ask more questions, possibly get some experts involved or our advisory board. As far as reporting, which is another slippery slope concern, I always recommend an Excel spreadsheet where you put all upcoming reporting in there and then calendaring in reminders of any reporting that has like a warning that comes up for everybody a couple of weeks in advance. I also think it's helpful. Things like private benefit, private annulment that put people to sleep, but are kind of sort of important. Assign those out to board members and have them present. It can be 10 minutes, it can be 20 minutes, but present on that topic. So for example, one of the member organizations I was working with had this whole private benefit, private annulment situation come up. And I sent them a couple of materials. I sent them some examples, some private letter rulings from the IRS and what they found okay and what they didn't find okay. And the board member kind of put this together in a neat little package, and it created an amazing dialogue. It's a great way to get board members involved, engaged. It's a great way to internalize the lessons, and it's a great way to serve as reminders to people, because again, these are things that maybe they've normalized, and so they're not necessarily thinking through what some of the problems can be. And then this nice little moniker that I use, don't pay unless documents say, is just a reminder to refrain from paying anything that isn't documented or a part of a documented process. So if you know that you're going to be making reimbursements, consider a reimbursement policy. If you're going to be paying out compensation, then have compensation policies. Question any situation where money isn't being spent on operations or programming. And more importantly, question any situation where one person, one group, one class is getting a benefit that no one else is getting. Normally that last one is a real big biggie because private endearment, private benefit in the US at least are some pretty vague, concepts that most people don't understand. But usually if you have a situation where you're giving someone just that a benefit that no one else is getting, then you might have a private benefit situation. So legal trap number 3, shaky practices with intellectual property. What do I mean by shaky practices? I mean creating and using intellectual property all willy-nilly, without much thought, without much processing, without much deliberation. And by intellectual property, I'm talking about those things that you create yourself or you have someone else create. And the problem here, the legal issue here, is that by not having a solid practice in place, it leaves legal ownership of that IP in the air. And it leaves you in danger of not only violating someone else's legal ownership rights, but you, organization, having to pay royalty fees that you didn't plan for. So how does this play out in real life? I'll have a client hire someone to speak at a gala. They'll hire a designer to design their site, a cartoonist to draw something for their magazine, and they make the mistake of not getting a contract in place. So first mistake, not getting a contract in place. I believe part of our oath as attorneys should be, everyone should be told to have a contract in place. And so first mistake is that. Second mistake that comes from that is that now we don't understand the rules of the road for that IP. And by that, I mean it's not clear how that's supposed to work, what that relationship is supposed to look like. Who owns the IP? In the US, the person who creates it typically owns it. And it's the same in Canada, with few exceptions. There's a few exceptions. Europe, typically the same. I found, Germany, France, and a few others. There can be some exceptions depending on the employment relationship, but normally the person creating the IP gets ownership of the IP. Where I see this becoming a huge issue for many of you folks is in photography. So what happens is, the photographer expects to own the image of what they've taken a picture of. And they may even slip language into some type of email or contract that they've signed with you that says that. Well, and it makes sense, if I'm on the photographer's side, because photography, pictures, are my bread and butter, and I need them for portfolios, I need them to be able to market, etc. But what I've had is, the next thing you know, clients of mine will receive a cease and desist for trying to use images of their own events. So I've had folks that, had operas, that had ballets. It seems to be in the arts it happens a lot now that I'm thinking about it. But they'll try to post images, or they will post images in their newsletters, on the website, and they will actually get a cease and desist letter from the photographer saying, you don't own that, and if you want to use it, you're going to have to pay up. Why does this happen? Because they didn't get ownership of the IP, the photograph, and they didn't discuss the rules of the road. So the solution here is very, very simple. Get a contract. Get it with your vendors. You really should have something in place also with your employees, with your interns. I'll cover the questions to ask in the next slide. But in terms of day-to-day transactions, do not be afraid of the template. The template is your friend when used correctly. I would not download templates straight off the internet, because what happens is I get a client that is in Texas that downloads a template with New Zealand law, and I'm not quite sure why that's in there, and neither are they. So I wouldn't use templates in that sense. But what I would do is, as a group, as a board, as executives, be thinking through, what are our IP policies? What is our stance in terms of, do we own everything that we hire someone to create? Okay, if we do, can they, the person who's created it, use it? If they can, what are the parameters? And then put that into a writing. Some situations I've had it to where people can circle to make it super easy, and so they'll just circle through all the questions. Others I've had it to where they can write it in. But consider having some type of template language that your folks can use, so you're not having to think about this in the day-to-day from scratch, because normally it's not going to come up until you actually need it. And then there might be some of you who are freaking out because you have IP that you did not discuss with the person who created it. If it is integral to you, I would definitely start thinking about a license agreement doubling back and just making sure that you outline what that relationship is supposed to look like. A real big one for this one is websites. I've seen nonprofits get locked out of their own websites by rogue designers. I've also seen, with software, where people have created software and again, they won't update it or make changes, or they'll have time bombs in it and say, well, if you want to continue using it, you're going to have to pay up to me. So anything integral for you, make sure that you have some type of agreement in place. And in terms of the questions to ask, again, who owns the IP? Who can use the IP? Is there a fee for use of the IP? How can it be used? Where can it be used? I would even say, why? Is there a why? Is there a purpose in which it can be used? This is also really important for you organizations that are in the science field. I've done quite a few consortium agreements. And, for example, if you've developed something in partnership with a business or with another organization, say it's like a matrix for health and making sure that people are safe when they are working on equipment. You may want to use that matrix in some instances exclusively, and then the organization may want to use it exclusively in other situations. And so all of that needs to be outlined ahead of time. Next one, legal trap 4 is not adjusting to employment growth. So one day it's just you and your husband running the organization. Then it's you and your husband and a somewhat flaky intern. Then the next thing you know, you have 2 full-time staff, then you have 25, then you have 50. And as you've grown, you have to be thinking about, have we kept up with the labor obligations that tend to grow with us? Because the minute you hire staff, there is a litany of federal acronyms that come into place. And they only add as you add staff over time. It's really important that you familiarize yourself with these. I do not expect that you read the statutes in their entirety unless you want some fun nighttime reading, but you do need to be familiar with the exposures that are there. For example, with the FMLA, what tends to happen is people get really confused around timing. How much time goes into giving them time off? For what reasons can I give them time off? Who can I give time off to? With the ADA, have we made the appropriate accessibility requirements? Are our premises accessible? Is our website accessible? Does it even apply to us? If it does, to what extent? The NLRA, the National Labor Relations Act, is a huge one because under the last administration, there were some pretty interesting interpretations that came from the National Labor Relations Board. And so things like "my boss sucks" can be protected speech in some instances, believe it or not. A lot of people in their handbooks had things like, you can't talk about us disparagingly on social media. Well, that was actually held to be a violation of the NLRA. Telling people that they can't talk about their salary, also held to be a violation. Telling people that they can't talk about investigations that may be done, also held to be a violation. So, these are exposures that a lot of people aren't familiar with, but it's really important that you do become so. And there also may be state-specific requirements around registration, workforce commissions, getting workers' compensation and things like that. So you'll want to know about those. Other things that can go wrong in the labor world: independent contractor versus full-time. This comes up, I think, in any and every labor-related presentation because it is always done wrong, and exempt organizations are synonymous for this. Why? Because they're usually very budget conscious, and they usually need someone full-time, but they only have a part-time or part-time budget. And so what happens is we hire people as an executive director and say they're a 1099, but then we treat them as an employee. Huge issue, because by doing so, what normally happens, and what I've seen happen to clients, is the ED says they're okay with it. I love the organization. I love the purpose. And they go along with it until they don't. And they get disgruntled. And then they file a claim. And the organization then has to not only pay back taxes to the IRS, but they've got to pay back benefits and a variety of other compensation to what was an employee. So make sure that you have those classifications right. I think it's the SS8 for those in the US on the IRS.gov website that has a list of considerations to be thinking about to determine who should be a employee and who should be an independent contractor. But Make sure to look that up if you haven't. And also make sure that you're prepared to handle EEOC claims, because these can come to you at a pretty quick clip if you're not prepared, and they can be pretty labor intensive in terms of not only responding to the claim, but getting all the documentation together and prepared for the claims. Other things: being lax and not documenting employee performance or having a yearly review process. I cannot tell you how many times I've seen clients and other organizations fire someone for an issue. It can be they're perpetually late. It could be that they didn't call in when they were supposed to. It could be that they don't wear shoes. True story. But whatever the reason is, there's one of two things I've seen happen. One is they fire this person, and maybe rightfully so, but that person files a claim and they win because there's no documentation of there ever having been a conversation and the employee an opportunity to remedy whatever the problem was. Or there is a file, but there was a super non-confrontational manager who wanted everyone to like them, and so they gave the employee 5 stars and didn't mention the fact that everyone was really uncomfortable that they didn't wear shoes. So if you have employees, you must have some type of process in place where you have the opportunity to not only help them with their growth, but also can serve as a warning system to say, hey, there's some things that we really need to work on, or there's some things that you are going to have to work on if you want to continue working with us. And in addition to the labor laws and systems, we need to continue thinking about culture and developing culture. Why? Because most people don't know the #1 claim that nonprofits deal with is not the slip and fall that we see littered all over the news and media. It is employment claims. And there is no bigger liability than a disgruntled employee. So when you bring people on, you want to make sure that there is some type of onboarding system, that they are comfortable asking questions, that people are checking in with them, that they're getting the tools that they need, that they're engaged, that they're happy. And then you want to make sure you've also got the rules of the road outlined clearly in an employee handbook. This doesn't have to be 200 pages. It just needs to be a simple explanation of things like calling in, vacation, behavior, etc. I say this all the time. With employment, what we tend to do is defer to common sense. Do not defer to common sense, because as my grandma would say, common sense ain't so common for everyone. So make sure that you have everything explicitly written out. And in terms of solutions for this, we talked about create the onboarding process, manage the expectations with the manual, labor sites. So the websites for most labor agencies, both at the state, provincial for you guys in Canada, and maybe even countrywide for you guys outside of the US and Canada, and states, they tend to be very helpful. I know in the US, the federal website is actually incredibly helpful. I know in Texas, the website is very helpful. It'll also have the posters you need to have posted, things to be thinking about, checklists. So if you haven't looked at the labor site for your state or location, do so. And also make looking at the employee stuff a priority each year. I just find it easier as a whole every year to do a scan and to make sure that you have feedback loops implemented throughout the year so that you can make sure, again, that you don't have those disgruntled employees. So alas, we're coming to our last legal trap. Be thinking of questions if you haven't already. This was pretty vague, but it's where an organization just starts to creep all over the map. The most prevalent is mission creep, but I've seen this happen with services, I've seen it happen with clients, I've seen it happen in many different iterations and ways. And there's a few different reasons that this happens. People follow program revenue, they follow foundation dollars, they follow trends, or maybe even the specific prerogatives of an executive director or board member and their agenda. Here's how that can backfire though. Client mistrust. I am a little nervous if you tell me that you help with workforce development and then all of a sudden you are saving kittens. It tends to breed a little bit of skepticism. Same with donor confusion. Creep may not be that bad, but if I'm donating dollars to you for one cause and I start to see your messaging and your newsletters and things go in a completely different direction, not only will I be confused, I may be affronted. as an aside, this could be a contractual issue as well. If I've made some type of endowment or there's some type of gift agreement that we have in place. There could be lost funding, especially when it comes to the government, because if I give you funding for a specific purpose, specific mission, a specific philosophy that you've presented to me, and what I start to see is something different, it may conflict with whatever agreement we have in place for the funding. It may conflict with what I thought I was actually funding, and so I may not fund you again. And lastly, stretched resources. When I see organizations who are struggling financially, a lot of times I can trace it back to stretched resources. They are in areas they should not be in. And were they to focus really on what they said their mission was, the core and crux of their mission, their dollars would go much further than they're actually going. But in addition to this, there's some more catastrophic things that we have to be thinking about. Allegations of fraud. If I'm telling people that I am fundraising for one purpose, but I use it for another purpose, that is fraudulent. And this becomes scary because it could be a deceptive trade practice violation. Many states in the US have a law around this. I know Texas does. There are civil penalties. It can be up to $1,000, I think, for each violation, if I remember correctly. But there are also criminal penalties. Even scarier, it doesn't have to be a board member or executive director that makes those misrepresentations. It could just be your development person who's making these misrepresentations. It doesn't even have to be an intentional misrepresentation sometimes. But again, if you say you're doing one thing and this is your mission, but you're using it for something else, then the money was arguably procured fraudulently. There could also be a claim of a misappropriation of funds. Again, saying that you've raised for one reason, but then using it for another. And then there can be trustee violations. You know, in Texas, you don't have that. I'm trying to think of a state off the top of my head that does, but what happens is there are some states that say, above and beyond your fiduciary duty as a board member, we find that you are holding public funds in trust of the public, and so there's an even higher duty when it comes to that, which means the consequences for getting it wrong are higher. And then, of course, it's a breach of your formation documents if your mission says you do one thing and you've pivoted and evolved into doing something entirely different. This gets into that snowball illustration earlier of, okay, it seems like small potatoes, it's just a paragraph, but if you're not following your mission, you're breaching your fiduciary duty, you've possibly violated the law of the location in which you're in, you could lose that indemnity protection we talked about, then could lose your D&O, and so it starts to snowball again. In terms of solutions, I think this is pretty straightforward. It's just awareness. You know, I don't think strategic plans are the panacea for everything. I'm not a big strategic plan person for any and all issues an organization has, but I do think there has to be some type of framework in place to understand where the organization is aligning itself and how its programming should work. Mission statement, mission statement, mission statement. This should be prominent, and it should be maybe recited before each board meeting so everyone understands any and every decision we make, from napkin color, well, maybe not napkin color, but every decision we make up into programming is really good. It needs to come down to what is our mission and is this in keeping with our mission? And if we find ourselves having to twist and turn and writhe to get it to fit within the mission, that tells us that either we have crept out of our mission or our mission no longer fits us and needs to be revised. Creeping is called creeping because it's slow, so make sure that you have feedback from other people who can let you know, hey, well, I thought you guys were really into this, and based on your messaging, it seems like you're really into that. It's a great way to be a reality check. And then board members, do not be afraid to speak out. Remember, you have a legal obligation to NARC. So if you do see there's some creep going on, you've got to speak out. It needs to be documented in minutes, and it may be a situation where you have to remove yourself from the situation. So I do have bonus for you guys, a little treat. Just a few things that I have also noticed that I wanted to make honorable mention of: not paying attention to fundraising requirements. So this is one that is really tough because I know in the US, each state can have its own solicitation laws. And it's really tough to tell many startup organizations, hey, you need to be able to spend a couple $1,000s to be able to comply with the fundraising requirements of, each of these different states. There's a unified registration statement out there that's supposed to help with that. Additionally, what I tell people to do is do triage. Look at where your money is coming in. If a good amount is coming in from New York or California, where you know regulation is pretty hefty, then we need to make sure that we comply. That does not mean that you do not need to be complying with Wyoming. It just means we need to make sure that we are mitigating the higher risks. And so, really looking at maybe where your top 5 streams are in terms of money geographically located, and then making sure that you comply with those is really important. Crummy whistleblower practices is another. I mentioned your disgruntled employee is your most important or biggest exposure. And so be making sure that there are some type of avenues and outlets for people to complain. I cannot tell you how important this is. Most employee claims I see is because employees were not heard, and they felt that they were not heard. And when they were heard, they weren't taken seriously. So have either a process with the board. There's some services out there, third-party services, where you can have a line and people can call in anonymously. It doesn't have to be as big as my executive director is siphoning money for his Lamborghini. It can be, I don't really feel comfortable with this manager. This coworker of mine is making abusive remarks, etc. But have some type of policy and practice in place that people can follow so that they know that they have some type of outlet. And speaking of policy, you don't have to have a true blue policy, but have a contract stance. We talked about the IP and how important it was to understand where your stance was on that. Similarly with contracts, so many people contract themselves into exposures that they don't need to contract themselves into. So be thinking about, as an organization, what liabilities are we willing to take on? You have likely and will continue signing contracts saying you take on all liability if there's an issue. If that is not okay with you, then that needs to be clear to employees, to staff, to the executive director, and that needs to be implemented when these contracts are being negotiated and signed. Do we need to own IP? How does IP need to work? What state law should apply? Does it really make sense for us to be contracting, with this website designer, and we're in New York and they're in, New Zealand again, and they're using that law? It probably doesn't. And then lastly, not keeping track of lobbying. All of us in some shape, form, or fashion do direct or grassroots lobbying. I think it's important to understand who you're touching and what impact it's having. But also, if you do a moderate amount, you want to make sure that you're not overreaching with thresholds that apply here in the US. And so outside of just thinking about the legal traps that I've seen, what my role, mission in life is to get organizations out of feeling like they have to depend on a lawyer for legal. I think, really the best way to help with claims is to take some type of ownership over the process. And so it's important to me that people really be thinking about, how do we find our own possible legal traps for our own organization? And a few ways to do this is be inquisitive, ask questions, don't put your head in the sand, don't doubt yourself because you don't have a legal background. Without taking a law school class or having a legal degree, that pushing someone down a flight of stairs may be a legal risk. And so, similarly, I have people who do event planning, who can run circles around me when it comes to permitting, people who work with families, who know the family code inside and out. Each of you has some experience in some realm that makes you far more of an expert in legal than myself, than you believe. And so don't be afraid to take ownership of that process, and don't remove yourself from the process, even where you do engage with a lawyer. Stick to the basics: who, what, when, where, and why. Get you very far. You don't have to know the statutes for everything. So if you say, hey guys, I'm feeling like this loan we made may have been an issue, you don't have to know that it's private benefit, private annulment off the bat. Just ask the who, what, when, where, and why, and it can get you really far. Get it down, write everything down, not only for memory purposes, but because it helps in terms of seeing gaps and being able to connect dots. And then don't do everything on your own. Use brainstorming or problem solving and a collective brain. Make sure you reach out to advisors, trusted stakeholders, etc. So I know I have talked incredibly fast because I wanted to get to the resources. So my blog, you can get through the link that Rano has been great to share through my website, where I talk about legal issues impact organizations. Of course, while Apricot is a wonderful resource, as evidenced by this webinar, JD Supra is a legal website They talk quite a bit actually about labor for those of you who think, oh, I probably need to look into that. Nonprofit Finance Fund and National Council are great for just some short snippets on issues that can come up day to day. And so that's the end. Here's my contact. But, you know, Donald, if you have any questions, I tried to make sure I stopped early enough that we can take maybe one or two. As a quick disclaimer, one, these are off the cuff, so I will do my best to answer, but the answer may be I don't know. And so I'm happy to follow up with you guys on Facebook. Also, if it is a situation that is a little hairy, probably refrain from getting into details, as there is not an attorney-client privilege. I just have to say that sometimes because some of the questions I get are a little scary. So with that, I'm happy to take any questions.
Great. Well, first of all, thank you, Erin. I've personally found that really, really informative, and as you might expect, we have a slew of questions to get to. So we'll get, we've got about, say, 10 more minutes, and then there's a few other things we just want to mention before the top of the hour. As Erin said, we also have the Wild Apricot Facebook group as an opportunity to carry on the conversation, and Erin will be tagged in that conversation as well. So it's just here with Ranos for pointing out some of the questions here. Okay, great. So with maybe, so there's a slew of them, so maybe, we'll do some rapid fire for the next few minutes. So one is with regard to private benefit, would that include the board not paying annual dues?
So that's actually a really good question. I haven't seen it in the negative, but I have seen, well, no, actually, maybe I have seen that. And we would have to look at the amount for that. So I think when you say not paying dues, what we would have to look at is, are they not paying dues because they're being subsidized? That could very likely be a private benefit. If it's just that they're not being invoiced for it, that's a really good question. I could see, you have a situation, especially depending on how much the dues are, where they're receiving something, or the question is whether they're receiving it. I would probably want a little bit more information. I would definitely, if you have a situation where your board members aren't paying dues, have some type of defense position available if they're the only ones. And so the defense position may be that's their stipend or compensation for their board service. It may be that it's a negligible amount. It could be any number of things. But I would definitely, if they're being subsidized by the organization, then I might either rethink that or again come up with a defense that is more grounded in compensation than just not charging them or paying for them.
Okay, well, thank you. On the IP ownership sort of question, so this is if the volunteers are not paid at all, does that mean they own the website they wrote since no payment was made?
That is a very good question. So as mentioned, usually the only exceptions for the ownership, and by that I mean the only exceptions where the creator doesn't own or can't say that they own it, is where there's an employee-employer relationship. And so if they're not an employee, you can make an argument it was a work made for hire, but as you said, they weren't paid, so they weren't hired. I would say that's a pretty dangerous situation, and I would definitely have some type of disclaimer or understanding in your volunteer agreement that anything that they've created is owned by the organization. As an aside, I have seen nonprofits lose, I haven't seen it recently, but I have seen them lose ownership of, for example, their social media channels where volunteers are running them, and it just became so synonymized and identified with them that it became their own intellectual property, and there wasn't an agreement in place. So definitely get some language if you don't have any.
Wow, to that one. So, wow, geez. Okay, something to watch out for. Okay, so if we use QuickBooks Online version, does that qualify for record keeping, or do we have to have print copies of certain reports?
That's a good question. So it does, that's a step up. That's applause for that, because there's many people who don't even use QuickBooks. You definitely would want to see what your state requires in terms of that publicity requirement, though. So it would likely meet your bookkeeping. in that you are actually keeping books. Now, how thoroughly, you can get into that. You definitely want to make sure that the bookkeeping is still pretty thorough. But secondly, be thinking about, does your state, location, country require that you have those printed out? I know, like I said, in Texas, if someone walks into an establishment and asks me to see my books and records, I need to have that available for them. And, you're likely not going to want to turn over a QuickBooks account.
Oh, we're doing well with the questions. I'm sure we can squeeze in a few more. So this is great. Thanks so much, Erin. Should employees sign performance review documents?
Absolutely. That's a really good question. And I'm sad I didn't mention that. I'm glad that was asked. So I would definitely have them acknowledge it. Now, you will have some crummy situations where they won't acknowledge it, and that will need to be documented. But that is the first thing that happens in these claims, is people tend to catch amnesia and they forget that they were told about a certain situation, especially where it happens multiple times. So first stance is always to get them to sign it. If they don't sign it, then there's other ways of documenting that they were notified, but I would definitely have them do that.
Sorry. If we are a nonprofit, but not a charitable organization, are there any special or different issues?
That could take a whole year.
Yes.
So, I work with exempt, not just nonprofits, and, with membership organizations, depending on whether or not you've got an exemption status, there is a whole slew of issues. I mentioned the whole private benefit, private annulment, social organizations with the 501c4s, and all that's going on with the political organizations. There's a slew of issues around that. In terms of day-to-day legal issues, just keeping up with membership, making sure that your books and records with members are kept up to date, that they're receiving notices when they need to receive notices, that meetings are being called when they need to be called, and protocol is being followed. It can go any number of ways. What I would definitely say is, normally where that question is asked, there are things already in mind, and so you might document those. And usually the IRS, if it's an exempt related question, has some really great webinars for some of the more specific C4s, C6s, and things like that. And if not, the United Way and others tend to have programs that cover some of the topics too.
Great. We've got a few more good ones. We'll try to squeeze in another couple. Let's try that. Okay, so do you know where it is written that a nonprofit can use some of the funds that they raise from the public for operations?
Where it is written, I think that's just presumed. So, it's one of those things. I hate that everyone treats nonprofits like they have to be anemic and using, the original Macintosh equipment. You can definitely use it toward operations. Now, there are, in some countries, some thresholds in terms of how much can go toward operations. So that may be where that question is coming from. And I would need to know what country you were in to know what that is. There are best practices. So as we know, the BBB, GuideStar, and a few other watchdog groups say that, somewhere anywhere from 20 to 30 to, no more than 40% is supposed to be used on operations. I think that is a really personal question. I have written on this several times, and having worked with businesses, you have to spend money on operations. There's no way to have impact and truly be sustainable and impactful unless you spend it on operations. And so it comes down to what's defensible, what's legally required, of course, and is it something that you feel comfortable explaining to your donors? But you absolutely have to spend some funds. Now, I will say there are some grants that say that they are only for programming. So if you have some type of gift acceptance agreement, or you have some type of grant agreement that has specific requirements, that's a little bit different, because now you've contracted not to use it for operations, and that happens a lot with foundations. But otherwise, if it's just general individual contributions that you're bringing in, I would absolutely expect that you spend some of that on your operations.
Thank you. Let's do one more quick one, and then we'll get to some sort of last critical items here. So anyway, this is the question. I have some questions about having family members as part of my staff in a nonprofit organization. Is that a problem? That's probably a common question.
That's a very common one. And most people I know, it is, I mentioned the husband and wife. It's usually the husband, wife, a cousin, and an auntie that starts the organization. It's not, well, so again, this depends on your geographic location. Normally, it is not a legal issue. It is certainly a best practice issue. You know, with the IRS, for example, if your board is entirely comprised of your family, it will raise a red flag. And there have been instances where they've denied exemption. There's questions whether or not they should, but there has been situations where that's happened. And so similarly, with a staff of all family, you're really going to run into some conflicts of interest issues. Those, again, in themselves are not legally wrong, but they could present some problems, and they could present some hairy situations where you slip into some of those questionable practices that we talked about that do present some legal issues. So I certainly wouldn't have all staff be family. If you do, it is imperative that you have a conflicts of interest policy that you follow, and that you have, you know, documented compensation, that you have documented reimbursement, and that everything is papered, so there's a sense of objectivity that's inserted that won't exist, you know, if it's just family making decisions amongst themselves.
Thank you so much, Erin. And to everybody here, just want to do a few more things before we wrap up. But I know there are a lot more questions, you know, which is why we do have our Facebook group. So certainly you can take your questions over there. And Rano is going to include the link to the Facebook group. So again, thank you so much, Erin. I really appreciate everything that you did, as I said, in preparation for this, and answering as many questions as you could. That's really, really wonderful. For everybody, we are going to share the recording with you in a follow-up email, so you'll get to review this material as well. There'll be a copy of the slide share as well. And, you know, before we move on, as I said earlier, I want to give everyone here the chance to ask questions about wild apricots. So we can carry on the conversation on Facebook, but, you know, we'll also stick around for questions that you might have about wild apricot. But let me first say that if anybody is interested, you know, in taking a look at our software, we do offer a 30-day free trial, and Rano is going to paste a link to the free trial there. We'll take you to our website. I'll put that link in the chat window. You can just click on that link that you see there. You'll come to our website. You can enter your email, your name, your organization name, and you're ready to start with your free trial. If anyone here does want to receive a call from one of our coaches, just type your phone number into the chat, and I'll make sure that one of our coaches gets in touch with you.